Welcome to People Places Planet Pod, the official podcast of the Environmental Law Institute, a nonprofit, nonpartisan organization working to ensure a healthy environment, prosperous economies, and vibrant communities founded on the rule of law.
This episode was brought to you in partnership with the American Bar Association, section of Civil Rights and Social Justice. Created in 1966, the section provides leadership within the ABA and the legal profession in protecting and advancing human rights, civil liberties, and social justice. For more information on the section, visit www.americanbar.org/CRSJ.
Hi everyone, I'm Stacey Sublett. Glad to be here. I'm a senior associate at Beveridge Diamond, and I'm here this afternoon with Ethan Shenkman.
Hi everyone, I'm Ethan Shenkman. I'm an environmental partner at Arnold Porter. I recently worked with Stacey in the Office of General Counsel at EPA, where I was Deputy General Counsel. I also teach environmental law at Georgetown, and I'm very happy to say that I'm a regular columnist for the Environmental Forum here at the Environmental Law Institute. It's great to be here.
So it's been a crazy ride since January 2017, and I feel like I'm back in administrative law and law school. How are you feeling about this? What are you seeing?
I think you and I have both lived through several transitions and administrations. I was an attorney in the Environment Division at DOJ in the transition from the Clinton to the Bush administration, and I joined EPA at the very beginning of the Obama administration with you. And whenever there's a change in administration, there's always an effort to take a look back at what the previous administration had pursued and to consider changes in direction, changes in policy. But I think what we've seen in the first 2 years of the Trump administration in the area of environmental natural resources is unprecedented in the amount of change that the new administration has attempted to effect, and in the checks and balances that we've seen being provided by the courts, by the Administrative Procedure Act, and by various litigants that we'll talk about that have really illustrated the limitations on executive branch authority and the sideboards on the ability of executive branch agencies to change course in policy and in regulations.
Well, yeah, to your point, Ethan, actually, yeah, I feel like we're seeing a lot of that activity play out in the federal courts, particularly with the administration's attempts to counter some of the Obama-era regulations. What are you seeing in this respect? What sort of major takeaways are you pulling from these crazy cases?
The first one that I want to highlight is a decision, in August by the D.C. Circuit, which set aside EPA's rule that had delayed implementation of the Clean Air Act's risk management plan program for 2 years. That's the program, the RMP program under Section 112 of the Clean Air Act that regulates safety of chemical plants and similar facilities. In response to a number of high-profile chemical disasters, including the one in 2013 in a West Texas fertilizer plant where 15 people died, the Obama administration promulgated a rule towards the end of the administration to bolster the requirements of the risk management program, beefing up requirements for emergency response planning, investigations, audits, information disclosure, and the like. That new rule, issued by the previous administration, was due to take effect in March of 2017. The Trump administration announced that this was one of the rules that they intended to reconsider, and EPA issued a series of orders delaying implementation of the Obama-era rule while they decided how they wanted to reconsider it and what they wanted to change about it. Eventually, in June of 2017, EPA issued a regulation. It actually promulgated a regulation that delayed implementation of the RMP rule by 20 months. And that delay was challenged. It was challenged by a number of environmental groups and a number of states who were focused not so much on the substance of the rule as they were on the ability of executive branch agencies to change positions, and in particular to call a timeout on the implementation of the previous administration's regulation while they tried to figure out what they wanted to do in terms of a new direction. And the D.C. Circuit said that EPA acted contrary to law and arbitrary and capriciously in issuing this 20-month delay without going through the necessary regulatory steps that are required under the Administrative Procedure Act. The D.C. Circuit actually said that EPA had made a mockery of the statute by issuing this delay without taking into account or seeking comment on or building a record to investigate the relative pros and cons of having the new rule delayed for that period of time. This was not the only recent decision that has addressed the power to delay or power to suspend regulations while a new administration figures out what, if any, new direction they want to take. EPA has, and other agencies have experienced a number of setbacks in this regard. And I think what this illustrates is it's a lot more difficult for new administrations to change course and change policy direction in light of the Administrative Procedure Act, in light of the courts, and in light of litigants' willingness to use the courts as a check and balance than you might think it is.
It sure sounds like it in terms of this the soap opera going on in our federal courts, and hearing how the strategy to delay and to create this timeout while the aircraft carrier is changing course is really interesting to see play out. So we've looked backwards at Obama-era regulations. What's actually happening with the promises that this administration has made in terms of new regulations? How is that working in terms of the timeline for the APA in a forward-looking sense?
Right. So, I think the first 2 years of this administration, if the administration is a drama, the first 2 years were Act One, and Act One was all about how to implement change itself, how to call a timeout, how to suspend or postpone or delay the effectiveness of the previous administration's rules while the administration decides what new rule it wants to implement to take their place. Act Two we'll see take place over the next 2 years as a number of commitments that this administration has made to promulgate new rules, new substantive rules to take the place of the previous administration's policies will come due. We're talking about a number of big ticket items, a new definition of waters of the United States, which this administration has said it wants to be more like Justice Scalia's opinion in the Rapanos case than Justice Kennedy's opinion. That's one thing that's on their list. A replacement rule for the Clean Power Plan, possibly a new mercury and air toxics standard. There's new standards that need to be issued under the Renewable Fuels Program. There's new standards for motor vehicles, controlling GHG emissions and regulating fuel efficiency. All of those and more are on the plate for the administration during Act Two over the next 2 years. But as you know, Stacey, based on our experience at EPA, the window that an administration has to get these sorts of major rulemakings done is less than the full, 2 years that they have remaining in the administration. That at some point, when we get close enough to the next presidential election, typically the executive branch decides that it needs to put its pens down, that it's too close to the next election to be doing more major regulations, either because they've run out of resources, there's a little bit of a regulatory bottleneck, or because they're looking to what may happen in a subsequent administration that could in turn reverse their policies. And I think you and I remember well our time at the end of the Obama administration in EPA, where we were waiting for the signal that we knew would be coming at some point from either the White House or the administration at EPA that it was time to put our pens down and stop issuing major rules, which we didn't do in every case, but
through the tape,
running through the tape. But there is going to be a limited window that's considered to be the prime time for getting these major regulatory initiatives accomplished. So I'm looking at end of 2019, early 2020 as really the critical time to see to what extent this administration can deliver on the major regulatory commitments that it's made, and do so within that window where they can have their own lawyers at the Justice Department defend those decisions, and have them litigated in court during this administration, so that there's less risk of a subsequent administration, should there be one, reconsidering.
Yeah, and I think we really saw that. I mean, the fourth quarter mentality in the Obama administration and the Obama EPA was definitely tangible in thinking about those last few months as we approach the change of administration. But I think also thinking about what we saw in the months right after inauguration with the Congressional Review Act and the CRA and those regs that were sort of a little bit later to the party, and how quickly that action was reversed. So yeah, that definitely, thinking about that 2020 deadline and how they're going to work up to that to fulfill some of these promises is really interesting.
So I wanted to mention one other, going back to the topic, before we move on, going back to the topic of the power of the executive branch to call a timeout on previous administration regulations. We've learned a number of lessons as this administration has attempted to use a variety of different tools to accomplish that end. And one particular one that I just wanted to mention that's different than what I mentioned previously has to do with a recent episode involving regulation of glider kits under the Clean Air Act's motor vehicle greenhouse gas and fuel efficiency standards. And glider kits are basically rebuilt trucks where manufacturers put new bodies on older diesel engines that have been retooled. And this administration announced, towards the beginning of its administration, that it was reconsidering whether the Clean Air Act regulations pertaining to greenhouse gas emissions and fuel efficiency should apply to glider vehicles. And so they were in the process of reconsidering that. One of the last things that Administrator Pruitt did before he left office was issue what's called a no action assurance memo, which is a policy statement issued by the enforcement office at EPA that it will not take enforcement action on a particular regulatory requirement. Fairly unusual to see a no-action memo being issued in the context of a rulemaking process while the agency was reconsidering a rule. That no-action letter was immediately challenged by a number of NGOs in the D.C. Circuit, which issued a preliminary injunction or stay of it. During this time, this was exactly the time that the leadership of EPA transitioned from Scott Pruitt to Wheeler, who became the acting administrator. And only 3 weeks after Administrator Pruitt issued this no-action letter, acting administrator Wheeler withdrew it, rather than defending it through the D.C. Circuit process. And he articulated, as the rationale for withdrawing it, that based on longstanding policy, typically no-action assurance letters are not issued in a sort of, in the ordinary course of a rulemaking process while agencies are reconsidering rules. So this was yet another, a different kind of attempt at calling a timeout while the agency reconsidered that met a premature end before it could be tested in the courts. But I thought it's interesting to mention, and yet another lesson for both this administration and future administrations in this context.
Well, Ethan, that actually raises an interesting question, too, about how the glider case and these other cases with this administration are testing some of our traditional procedures and processes. So begs the question, what's the lasting change of this testing? What sort of impacts do we think will come from this administration's slightly unorthodox testing of our more traditional processes?
Well, on the one hand, we've been discussing mostly this administration's attempts to change on the substance of policies. Mm-hmm. But there's also been a focus during these first 2 years, quite an interesting focus on the rulemaking process itself,
Right.
Which has received some pretty significant attention from a variety of agencies. So, for example, EPA in June issued a notice of proposed rulemaking, an advance notice of proposed rulemaking, where it solicited comment on changes it can make to how it considers costs and benefits in the rulemaking process. Mm-hmm. This is separate and apart from any particular program, any particular statute, but just in general. Are there things that EPA can do to improve consistency and transparency in considering the costs and benefits in the rulemaking process? And EPA solicited comments on issues, for example, going to whether agencies should do more retrospective analysis of the costs and benefits of rules that have been implemented over the years. Whether the agency should and how it should consider the ancillary benefits of rulemakings is another a big issue. Mm-hmm. That's actually one that is quite relevant to the mercury and air toxics standard, which regulates emissions of hazardous air pollutants from power plants. And as we know, the Supreme Court reversed an Obama-era regulation, which for failing to consider costs in the context of finding that it was necessary and appropriate to regulate air toxics from power plants. And the Supreme Court sent the case back to EPA to consider costs, but did not specifically tell the agency how to do so.
Right. And
the agency on remand in the Obama administration redid its necessary and appropriate finding and supported, reissued the rule, the mercury and air toxics standard. And among other things, when it measured costs and benefits of regulating mercury and other toxics from power plants, it looked not only at the benefits of regulating those substances, which were the principal focus of the rule, but it turns out that the same controls that are necessary to control hazardous air pollution would also result in significant decreases of conventional pollution like particulate matter, which causes respiratory ailments and deaths in a broad swath of society, and particularly in vulnerable individuals. And it has been much easier for the agencies to monetize, to decide what kind of a dollar value to place on control of those kinds of conventional pollutants than it has been for them to monetize the benefits of controlling mercury and other toxic pollution. But EPA felt that it was appropriate to consider not only the benefits, not only the monetized benefits of the control of the mercury and the toxics, but also the ancillary benefits that society would experience from the incidental improvements in air quality that would result from the decrease in particulate matter and other conventional pollutants. That has proven to be a big issue of contention. There's arguments on both sides, and that's an example of an issue that EPA is now taking a very hard look at, both in the context of this solicitation of comment on how to engage in cost-benefit analysis, but also in the context of a variety of rules, such as the mercury and air toxic standard.
How does this play into, I think, the social cost of carbon issue as well? Is that something that's also on your radar?
It is, and the social cost of carbon is a metric that the previous administration used to monetize the benefits of reducing greenhouse gases that cause global warming and climate change, to actually put a dollar value on each metric ton equivalent of carbon dioxide that's reduced in the atmosphere. And this was an important metric in a number of rulemaking efforts in order to provide information both to the agency and to the regulated community and to the public as to what the relative costs and benefits are of regulation. When the Trump administration came into office, one of one of the many things they rescinded during the very early days was this social cost of carbon metric, which they felt was riddled with uncertainty and had a lot of methodological flaws. They haven't replaced it with a different metric, but we're seeing in a number of rulemakings, whether it's the motor vehicle greenhouse gas standards or other regulations that deal with greenhouse gases, we're seeing the administration come up with significantly reduced dollar amounts for each metric ton of carbon that is reduced by the rule, and as a result, the costs of these rules are all of a sudden appearing to be much greater relative to the benefits. Now, this hasn't been tested in the courts yet, and it's one of the things that I think all of us who practice in this area will be looking for over the next 2 years is the extent to which where EPA finally lands in these various rulemakings on the issue of social cost of carbon, or how to monetize and measure the costs and benefits of a rule aimed at reducing greenhouse gases, and the extent to which that cost-benefit analysis will be taken up by the courts as they review these regulations, how changes to the rulemaking process itself that cut across statutes, cut across programs, are actually some of the more significant changes that this administration is considering that could have a lasting effect, not on just one particular program or one particular statute, but on the rulemaking process itself. And so that's something that we're following very closely. One other thing I'll mention, because it's an example of yet another tool that an executive branch agency has used to try to change policy direction, and that is through the use of issuing legal opinion. It relates to infrastructure, and it relates to infrastructure in the renewable energy sector. My example has to do with the Migratory Bird Treaty Act, which prohibits, to sort of simplify things, it prohibits the take of migratory birds, and there's long been a controversy and a dispute and divided views among the courts as to whether the prohibition on take is limited to intentional take, as in, when a poacher or a hunter shoots a bird, or whether it also extends to incidental take, so that when you have a major infrastructure project or a wind turbine, and there's inadvertent bird mortality associated with that project, or power line, or a construction of a building, is that covered by the prohibition in the Migratory Bird Act? In the previous administration, the government took the position that yes, it does cover that kind of incidental take, and there were efforts to try to provide guidance to the wind energy and other sectors, and explore pathways to a more rational permitting process. This administration, that culminated at the end of the administration in the solicitor of the Department of the Interior issuing a formal legal opinion providing legal support for that position. This administration has reversed position and done so through the issuance of a new legal opinion by the solicitor at Interior, who is now taken over, and who's issued a legal opinion taking a polar opposite view of the law, which has now been adopted by the wildlife and land management agencies. One of the things that will be interesting to see is how durable this tool is for changing positions through issuance of legal opinions. The solicitor's new legal opinion has now been challenged in court. It's been challenged by both environmental groups and a number of states, which is going to raise interesting questions about whether it constitutes final agency action, whether it's ripe for review, whether it's something that courts can review at this time, or whether it requires a particular case. But it's also going to it'd be interesting to see whether changing positions through issuance of legal opinions is something that will last through administrations, over the years, or whether it's something that can just change again when, if and when we have a subsequent administration, starting in 2021. Is that something that can be easily reversed? How does that compare to the other tools that the executive branch uses to change policy direction?
Do you see any impact from any of the internal memos that the agency has written as well? I know this dips more into DOJ, just thinking back to when Attorney General Sessions issued that internal memo of DOJ about supplemental environmental projects, and in terms of directing the course of the agency through internal guidance. Is that something that you see playing a role at all?
Well, one thing this administration has expressed skepticism of, and particularly out of the Justice Department, is using guidance documents to regulate outside of the government, to impose enforceable requirements on regulated entities through the use of guidance documents. That's something that this administration has made very clear that it is not supportive of, and the Justice Department has issued some very strong policy statements discouraging agencies from doing anything that comes close to that. But I do think that within the federal government, within the executive branch, it continues to be a necessary tool in the executive branch's toolbox in order to try to exercise some control and some uniformity among its federal agencies, and to make sure that the policy direction that's coming from up top is actually being followed by the agencies and their various departments. And we're seeing this administration both issue new guidance documents and rescind guidance from previous administrations, and I think that's something we'll continue to see.
Well, thank you so much for joining us, Ethan. This has been a wonderful conversation and a great reunion. Look forward to our next chapter.
Thank you for tuning in to People, Places, Planet Pod, brought to you by the Environmental Law Institute. We would like to hear from you, so please send us your questions, comments, and ideas to podcast@eli.org. And if you're interested in learning more about our work, attending one of our events, reading our publications, or becoming a member, please visit our website at www.eli.org.